Hey, good afternoon, everybody. Make sure my volume is set right. Hope you're all well. Today is July 20th. We are starting Module 4, hard to believe, but this is where we really get into the meaty stuff. You submitted your first milestone assignment yesterday, or at least it was due yesterday. And I look forward to looking at those and providing feedback. So please don't stress about it. Don't worry about it. We'll work through each one of those sections. I know there were some questions in terms of sort of how to respond to certain sections, and hopefully I can respond to those with some clarity in my feedback. But if you're still not clear, please feel free to reach out to me, and we can try to clarify it for you. So anyways, this week I want to talk a bit about medical records. If you haven't taken a look at the week 4 discussion question already, we're going to tackle that at the end here, give you some thoughts about that on how to move forward with responding to that, and just the analysis involved in that. So medical records is really governed by both the federal level and the state level. So we work in healthcare. We're familiar with HIPAA, or at least we should be. I hope we are. I think I've mentioned before, it's comprised of 3 different rules. It's comprised of the privacy rule that governs when you can have a permissible use or disclosure of protected health information. It's also comprised of the security rule that really governs the physical, administrative, technical safeguards that should be put in place in order to protect against security incidents, against breaches of protected health information. And also the enforcement rule, the breach notification rule. I kind of lump those into one at the very end. So we're not really talking about technical, administrative, physical safeguards in this class as it pertains to medical records or protected health information. We're going to talk mostly about privacy, the privacy rule. And really under HIPAA, there are very few instances in which disclosing medical or protected health information is required. A lot of the rules is generally not allowed unless an exception applies, and we've covered that already. But there are very few instances in which disclosure is required, and they largely surround patient access. So HIPAA gives patients or those that are the subject of the protected health information a lot of rights in terms of requesting an accounting of disclosures of their protected health information, access to their health information, as well as the right to inspect and amend and request an amendment of their health information if they feel like something is incorrect. As we know, HIPAA applies to what's called a covered entity. There are 3 types of covered entities. There are healthcare providers, there are healthcare insurance companies, health insurers, and there's something called a healthcare clearinghouse. Those are largely just intermediaries between a provider and an insurance company that stores health information. So all the HIPAA privacy rules, the security rule, and everything that goes along with that, the statute, the regulation, that applies to those 3 types of entities. And not even that, it's actually narrower than that. It applies to those 3 entities if they actually submit electronic claims for payment electronically. So if there's electronic claim submission between a provider and a healthcare insurer or a third-party payer, then HIPAA would apply. Now, if you have a cash-only healthcare provider that submits no claims, does not accept insurance company, strangely enough, HIPAA doesn't apply to that provider. However, that's where we get into the state privacy laws. So all the states have privacy laws, some data privacy laws, some specific just to healthcare records. Well, they have their general data privacy laws, and they have a separate law related to healthcare records. Some that mirror HIPAA, some that are more stringent or more restrictive than HIPAA. So to the extent that HIPAA would not apply to that cash-only business healthcare provider, certainly the state healthcare data privacy laws would apply. So to the extent a lot of people get confused on if HIPAA would preempt or would basically preempt the same sort of state law, and the rule is that if there's a state law, there's a law under HIPAA or some other federal law, and they conflict, then HIPAA would be the controlling law. The only time that the state law would be controlling is if the state law is more stringent or more restrictive. So, for example, if the HIPAA said you have to provide a patient with access within 30 days of the request, but the state law said you have to provide access within 15 days of the request, and the state law would control because it's more stringent or more restrictive, or requires more than HIPAA would. Okay, so I think that is the main issue. I mean, there are many other laws that relate to medical records and requirements. HIPAA, there's Medicare rules related to largely around documentation, Medicaid. The one other thing I wanted to talk about was record retention rules. So a lot of people get confused and think that HIPAA has a record retention requirement. And that's not true. So HIPAA does not have a record retention requirement, but it does require covered entities, business associates, to maintain HIPAA documentation for 6 years. So that's not just protected health information. That's not just medical records. That's all their documentation. So all their policies, their patient authorizations for the release of medical records, all their trainings, even like their PowerPoint presentations for trainings, and all that documentation, a covered entity has to retain that for 6 years. But there's no record retention requirement. Medical record retention requirements are governed by state law every time. So the state law will say 10 or 15 years. It depends on the state, 10 or 15 years, 20 years maybe from the date patient is, or from the last visit, or from when the patient becomes the age of majority. So that's generally how that's measured. But the number of years can range pretty widely from state to state. So, and then there are other requirements. Some state health departments require notice to patients as well as to the state agency when, for example, records are moved. If there's a provider that's retiring and they're going to move their records to storage, it requires notice. It requires retention up through what the state law requires. So there's a lot involved in that. I want to talk about the discussion question a little bit. And the reason this is my favorite discussion question in the class, and I really enjoy seeing students react to this and seeing their analysis to this question, because really this really gets at the heart of what we've been talking about in terms of legal analysis, that IRAC method of legal analysis, the issue, rule, application of facts, and conclusion. So here in this discussion question, you have a physical therapist receives a phone call from a person demanding to know when her daughter-in-law's next appointment is. The therapist tells the woman that she cannot disclose any information. The woman becomes angry, abusive, threatening. After the call, the therapist logs into the electronic medical record system and makes a note about the conversation. And when she looks up the record, Since they share the last name, the person on the phone and her daughter-in-law, the therapist accidentally accesses the woman's record instead of the daughter-in-law's. The therapist realized the mistake, but not before spotting that the woman suffers from a serious mental health disorder. Therapist mentions it to her supervisor, mentions the possibility of a complaint, and also mentions that the woman has a history of mental health problems. So really you have two separate issues, right? You have the issue of the inadvertent access to the wrong medical record, and then you have the separate disclosure of the mental health issue to her supervisor. So the question is, so if you think about this through the lens of that Iraq method of legal analysis, so what's the I? The issue is, I mean, that's the question. Was there, and it's given to you, do you feel that there's been a breach of confidentiality? So that question needs to be asked twice because there are two different fact patterns, two different fact scenarios. So you know the issue. So what's the rule? The question is, was there a breach? So if you look at HIPAA and the privacy rule, and I will post this, the reference in my announcement for the week, but the term breach is a defined term. I think if we're not involved in this from day to day, I think the easy way to think about this is, oh, well, she shouldn't have done that, therefore it's a breach. And that's the wrong way to think about it, because we don't know what a breach is. So the term breach is defined in the regulation. I will post the reference to it. And you'll see once you read that breach, the term breach, it actually requires an extensive analysis. There are different factors to consider. There are exceptions to consider. And so it's important to go through that. What is the rule? That's the rule. So you got the issue, you got the rule that I'll give to you. Apply the facts to that rule. So the rule, the definition of breach consists of factors to consider. Apply the facts to those factors, and then give me your conclusion on both those scenarios. So it's really a great exercise of going through that methodology of legal analysis. You got your issue. The rule is the definition of breach, which I'll give to you. Apply the facts to that rule, and then come out with your conclusion. Remember, I'm not interested in whether you're right or wrong. I'm not grading on right or wrong answers. I'm grading on the substance of the analysis. And so that's really the key thing I want you to take away from this class. That's one of the key things that I'll be grading on in the ITRAL milestone assignment. And that's really the key issue and the key exercise in this discussion question. So that's all I have for this week. Hope you're having a great week. Please feel free to reach out with any questions. Almost halfway there, so hopefully you're going to stick with me. We'll get through this, and you're going to get some value out of the things that we're talking about. So have a great week, everyone, and take care. Bye.